I have Jeff on the phone. I'm George. This podcast topic is going to be specifically on long-term planning. And these are things here that every adult needs to have. Okay. And so if you want more information, contact me or Jeff after the call. If there's things that fall under Jeff's wheelhouse, we'll get you over there. If there's things that fall under our wheelhouse, we'll get you there. Our contact information will be anywhere around this podcast. So without further ado, we'll jump in. I am super excited to have Jeff on this podcast because these are topics that I'm extremely curious about myself. That kind of there's some overflow in my career as a CPA on these topics, but they don't go as far as Jeff goes into these topics. And this is something that is extremely important for everybody to have. And I'm personally very interested. So without further ado, we'll jump right into it. Jeff, why don't you give us just kind of a brief introduction about who you are, what you do?
Thanks, George. Appreciate the opportunity. Yeah, I've been an attorney for about 15 plus years now. This is probably my fourth career. I started long ago in the Air Force as an intel coordinator, and then I ended up being a programmer for 17 years after that. Then I got my MBA, did management consulting for 5 years, and then ran away and joined the circus and went to law school. When I got out of law school, I opened my own practice, and I've sort of been practicing on my own ever since. I do a lot of estate planning. I do asset protection. I do probate and trust administration as well as litigation. And excuse me. And this is sort of my favorite area to be. It's so nice to be able to help people with these things.
Now, uh, there's a lot of times confusion when it comes to clients having where that surround things having to do with states. Okay. Is there anything that we need to know that a client needs to know if they're going to approach you in terms of, let's say you have a beneficiary in the state of Indiana, but you have somebody else that's a member of the family in the state of Washington. You have somebody else that's in California. How do all these states play into each other, and what part of them can you advise on, or can you do the whole thing?
Um, as far as advising, if someone's just receiving an inheritance and they're out of state, then that's usually very seamless or pass through. There really isn't a lot of state specific things that I'm aware of, at least that are involved in an executor. I'm licensed in California, Montana, and Wyoming, um, and so those are really the only states I can speak to. But most of the trust law or the estate law is based on the estate where the administration is taking place. And most trusts that at least the ones that I draft, are considered to be interpreted under California law. And so, and if it's being administered in California, then there's no question as to what state's law is effective or is applicable to that particular estate. Does that answer that question?
Yes, absolutely. So now, estates and trusts are this kind of concept that is uh, very confusing for a lot of people. And many people aren't thinking about dying, and it's a topic they want to avoid in many cases. And I think maybe that might be one reason, but I see a lot of clients of ours and just people that I meet that are in their 20s, 30s, or 40s that have substantial wealth or that even have a comfortable middle class lifestyle that haven't really thought about estate or trust planning. Can you kind of go over why you should have it? What are the essentials and what does it really do?
I think that having proper estate planning is actually more critical for younger people who are in a family mode or building their wealth or their family at the time. Um, some of my saddest cases are cases where the husband or the wife dies unexpectedly, leaving the other spouse and kids and a bunch of assets they don't that the surviving spouse may not understand. I may not understand where things are at or how to deal with them. I've had situations where the husband owned an entire car dealership, and the wife had no idea what was going on in this car dealership and had no one she could count on to sort of give her advice on that. Also, the husband had owned everything on his own because he was out doing business, and so she didn't know where anything was at, what the value of anything was, and so you end up in a situation where you're doing things quickly or on an exigent or emergency basis, where things can fall through the cracks, things get missed. Meanwhile, the family and the wife and kids are sitting there saying, we've got mortgages to pay, we've got bills to pay. Where's the money that husband was bringing in all this time? And there might be money there, but maybe they don't have access to it yet. So then we're resorting to going back to the courts and asking for court rulings saying that this money belongs to the surviving spouse rather than just the spouse that's passed. So it's very most people think of estates for older people who are reaching the end of their life, and they want to make sure that the assets that they've accumulated over the course of their life go where they want them to go, and the person in charge is the person that's stepping up to actually distribute those assets properly. But the harder cases are the cases where it's a young family. There's tuition coming up, there are medical bills due, insurance bills due, and if the surviving spouse doesn't know where that stuff's at, then all of a sudden it's the spouse needs something, the attorney has to find out about it, there has to be something filed with the court has to come back to us and give us permission. Then the surviving spouse can then take whatever the court says to the bank or the investment company and get those funds released. Unnecessary delay, unnecessary stress. There's too many people running around. Plus, at that point, things started getting expensive as well because you've got an attorney in this thing trying to handle both sides of that, or the communication from the surviving spouse or the surviving family to the court. And that's all of a sudden you're starting to rack up hourly billable hours, and it can be quite much more stressful than it already is because it's already stressful if a spouse has passed away. You're dealing with the young kids, you're dealing with all the regular parts of life, the bills and the obligations the family has, and you don't have an idea where that's going. And so I generally encourage anybody who's accumulating any level of wealth whatsoever to have an estate plan, especially in California where the fees can be so expensive.
You brought up a really good point, and this is, I hear all the time attorneys mention things such as you want to avoid probate, and this is what we can do to avoid probate, and there's this focus on avoiding probate, and I love how you put kind of a very practical note to this. You're racking up fees. You're racking up professional service fees for your attorney, and the time frame. Now, can you explain a little bit about why probate should be avoided, other than the costs and the delays? What are the reasons why people look to avoid probate, or are those really the main ones?
Well, if you're going into probate, if you have any real estate at all in your estate and you pass away, if you go into probate, and you may think that, well, I've only got $400,000, $500,000 worth of equity in this piece of real estate. But what you're missing is that probate fees are calculated based on the gross value of the items in the estate. So your $400,000 house is really a $1.5 million house. I'm just talking for the greater Bay Area here. And your probate fees are going to be based on that 1.5 million, which all of a sudden starts racking your probate fees up to 40 to $50,000 for the fees alone. And then there's also the delay, the delay component, where you can file a probate petition. The absolute quickest you can get out of a probate petition is 4 months after the probate petition is granted. So you're talking a 5 or 6 month delay at that point before the assets can go to the family. There are ways to move the assets out of the estate and into the family under family allowances. But again, you're talking more billable hours, more attorney involvement. Um, so there's your delay and there's your expense, right? Um, again, if you have a piece of real estate at all, you really need to have it in a trust because, well, I guess another thing that relates directly to what we were talking about is if you're a married couple and you have one or two kids, if the one of the spouse passes away, and that property is considered separate property, that community property, then the property goes 50% to the surviving spouse and 50% to a single child. So you all of a sudden you've got a minor who is set up to receive what 50% a 50% interest in a house, where when what you really intended was that the surviving spouse would have everything. In most situations in California, things are titled it as husband and wife in community property so that the surviving spouse takes the property outright. But if it goes through probate and if you get stuck in probate, then the financial accounts, those are to be distributed between the surviving children and the surviving spouse. If there's more than one child, the surviving spouse under intestate rules, which is means without a will or without a trust, under intestate rules, the surviving spouse only gets one third of the value of the estate, and the other children split the remaining two thirds. So you start taking money away from the surviving spouse, who's essentially been sitting there the entire time, assuming that they would be receiving everything, and you're giving it to children that may not be in a position to manage those funds, or may not be able to manage those funds, or maybe under the age of majority and not able to effectively use those funds on their own behalf.
Wow. So you've seen situations where there is an inheritance, and because there wasn't proper estate or trust planning, instead of the assets going to the surviving spouse, they get divided up by the courts based on the court rules between possible beneficiaries, including children that might not even be 18 yet, and that it's kind of dividing up assets, and possibly even assets that really shouldn't be divided, such as interest in a house or things that you can't really, or interest in a business. It's going to be very hard to divide, right? So I guess one topic here is that it comes up every time there's a change in administration or there's a change in rules. Has to do with planning how much you can give, because one thing a lot of people don't know is how much estate taxes are. If, let's say, you pass this threshold, which now I think is 14, 15 million, let's say you pass this threshold, the amount of taxes that you pay on this is huge. And what's crazy to think about is you've already paid tax on this money when you are earning it actively, and then all of a sudden it gets taxed again when it goes to let's say your child or your grandchild or whoever it's going to. So proper estate and trust planning is very important. And I guess a kind of an open-ended question is, what can people do? Let's say they have a net worth of over 15 million. What can they do to use this to the best of their advantage and be able to save tax to the furthest extent possible?
What we do in those situations, and what I do in almost all situations, is I keep in what I consider to be discretionary estate tax planning. When the first spouse passes away, there's a limited amount of time to use that spouse's estate tax exemption. And as you said, right now we're right about $15 million per spouse. But if you don't use that spouse's estate tax exemption, then it expires. And then when the second spouse passes away, then everything comes out of one trust. What the revocable living trusts that I put together have the ability to segregate assets into an irrevocable portion of that trust. The decedent's trust, or the estate tax exemption trust, or the credit shelter trust. It goes by a bunch of different names. But what that has the effect of doing is utilizing the first spouse's the estate tax exemption of the first spouse to die. So if you've got say you got $30 million in your estate, congratulations. If you don't do something about that, it's going to be taxed at 40% for every dollar above the $15 million exemption. And again, we're just talking general numbers on exemptions. But if you're a married couple and you've got that much money, the first spouse passes away, you segregate $15 million worth of assets into the deceased spouse's portion of the estate, and it doesn't get taxed on that basis when it's distributed. The money stays there. The income and sometimes the principal are available for the surviving spouse if necessary, but the surviving spouse carries their own $15 million exemption. So that has the effect of, when the surviving spouse or the second spouse passes away, there are two trusts that are distributing 15 million bucks a piece, and you avoid your estate tax exemption. So because both trusts are below the threshold, there's no estate tax calculated on either trust.
Now, one thing that makes people nervous is this word irrevocable. It has this permanency to it, and it sounds frightening, especially with people that might be younger. And like you said, Jeff, the saddest cases that you mentioned are ones where it's a younger couple, and then once a person suddenly passes and there's this mess. So how can you I guess, make this less scary? And what does irrevocable mean in this context? What's the mechanism that makes this make sense for people?
Well, the fact that to me, it makes sense because the surviving spouse still has access to all the income and in many cases, can actually invade the principle of the irrevocable portion of that trust. That has downstream tax implications that are way above my pay grade, and I'm not qualified to answer. But the it, the irrevocability is essentially, you can still modify an irrevocable trust. You're not supposed to. You're supposed to get permission from the court to do that. But in most situations and in most trusts that I write, the irrevocable portion of that trust, not only pays all of the surviving spouse the income from any activity that goes on the irrevocable side, but it also allows the surviving spouse to invade that principle if necessary. If the surviving spouse's assets have gone away or there's some problem there, the surviving spouse is supposed to use their own portion of the estate for their needs, but they are able to actually invade that if necessary.
Got it. So let's use a fictional example. Let's say you have two spouses and both of them are 100% owners of their own S corp. Very common arrangement for some entrepreneurial couples that we meet here and there. So would let's say we'll use me and my spouse as an example. Would each of us take our S corp and put that into an irrevocable trust? Is that what the mechanics would be, or what are the mechanics in this type of situation?
In situations with S corps, what I typically do is an assignment of interest of the spouse or of the owner of the S corp to the revocable living trust. Okay, that takes care of one thing when one of the
Now
spouses.
that's a revocable trust,
Revocable
right?
trust. Yes, the revocable
Got it.
portion.
So that one is not going to have to file its own tax returns or have a different structure. It goes directly through a K-1 to the personal. Essentially everything still flows through to the
Everything's
person,
still
right?
the thing. Nothing changes. The assignment is there for if that spouse passes away, and you need to gain control of that. You need to gain control of that S corp. You've got an assignment of interest from the spouse that is in our situation or in our hypothetical has passed away, and their interest is assigned to the regular revocable living trust. The surviving spouse then, as in most cases, is the sole trustee. The surviving spouse then steps in and has control of that S corp, and can either put that S corp into the revocable portion of the revocable living trust or the irrevocable portion of the revocable living trust and treat it accordingly, or keep it in the marital side of the revocable living trust and have full access to everything. So it isn't
And
something.
that avoids the probate process when this
Yeah,
happens.
exactly, exactly.
Got it. Now, how does that feed into the 15 million exempt lifetime exclusion?
It still has a valuation. There's still a value to that asset. So what needs to happen on trust administration, or when one spouse passes away, then administration begins. And so you have to figure out the valuation of all the assets that were in the name that are in both spouses' names at that point, to determine what the best allocation would be, to make sure that you not only leave plenty of assets there for the surviving spouse, but you take advantage to the extent necessary of the decedent spouse's estate tax exemption.
One thing that I see that's very common is this type of planning. This is kind of on a separate topic. This kind of planning having to do with people when their parents start becoming, older, and there's a chance that they may need to have more intensive services to take care of them. Okay, and there is this concept that 5 years before this date certain actions need to be taken, and things need to be put in motion to where the government essentially is helping out with some of those finances rather than everything having to be financed out of the pocket of the family. Do you know about that, and how does that generally work?
That's not one of my primary areas of practice, but my understanding is that deals with Medicaid clawbacks, and in California, we're lucky enough to only have to deal with Medi-Cal clawbacks, and Medi-Cal isn't as aggressive as many other states are. If your property is in any sort of trust whatsoever, Medi-Cal ignores it. And
Really?
there used to be some asset testing and some valuation testing on the death of the spouse. Medi-Cal doesn't do that any longer. So we don't have the problems of Medicaid planning that many other states have.
Now, we have a lot of clients, and you may see this as well, because we have so many clients that work between San Francisco and Seattle, or work between San Diego and Austin, Texas, or work between San Francisco and Austin. Most common ones are clients moving back and forth from any combination of San Francisco, Seattle, Austin, and some of the East Coast kind of tech areas, tech hubs. When you see this kind of situation with the spouses moving every 2 to 3 years and they're accumulating assets in all these different states, how do you reconcile all this? You mentioned that let's say their home state is in California, okay, then you would defer to California rules. But what about all these other states? What happens? Do you need to have a whole team, Jeff, to work on this estate, or how does that work?
Okay, I'm gonna start my answer to that with I don't know for sure. Okay. My understanding though is that if you have a trust under California law that's being administered under California law based on based on your residency or based on the actual trust language, then you're under California law, and the other states aren't going to aggressively pursue clawback for Medi-Cal or Medicaid expenses. Honestly, George, I don't know all the details of that particular answer.
Yeah, no problem. We have, I'd say, because so many of our clients work in technology, obviously we're going to be very California heavy on the personal tax side. So any of those clients can know to contact you. And you mentioned also you have Montana and Wyoming, I believe you said.
Yes.
Um, but if there's a client that has a need outside of those states, we could talk about that. We could talk about that. What happens? I mean, and if they wanted to contact you, what would you say?
I can deal with anything on the California, Montana, or Wyoming side, but if there are you mentioned Austin for the tech market there. I would defer to a Texas attorney on that, in terms of what Texas is able to go after in terms of clubbacks or assets of the decedent.
Got it. And so, in a community property state, versus one that's not a I mean, I don't recall off the top of my head if Wyoming or Montana are community property states. What differences are there?
Well, in a community property state, all assets of the marital community, or anything that's commingled or anything that's jointly owned or jointly paid for, jointly serviced, are considered by default to be community property, which essentially means that the surviving spouse takes the asset. The problem comes into existence when there are things that are perhaps not as clearly community owned, like you mentioned S corps. An S corp owned by one spouse might not be considered an S corp for the sake of the community, or a community asset for the sake of the community, and would be divided differently. That's why the assignments are so critical to make sure that everything goes where it's supposed to go.
Got it. So let's say that the couple lives in another state, but they purchase a property in California. Are they subject to community property if one of them is deceased, or how does that work?
Hmm. My I don't know, George. I'm sorry. I haven't had that one come up to me. I'd rather tell you I don't know. I know what I think would probably be the right answer, but if you think the law is on your side and you don't look it up, then it's always against you. You're always wrong.
That's a really good point, and I tell the clients all the time. If you have a tax question, whatever the least appealing answer would be, that's probably the right answer. It's
I tell every client that comes in, if they start asking me for like in-depth tax advice, that if you're actually I can barely spell the word tax. If you're asking me for tax advice, you're in the wrong office.
Right, right. So, the even on the tax side, I appreciate what you said, Jeff. And one thing that encounter is, I'm a licensed CPA in the state of California and a few other states as well. And and with our license, it's transferable in all the states. But that aside, what I found is that there's this perception that if we have this license or we have this kind of title, we should know every part of the code. And that's not always the case. Sometimes you have to do your best. And there's another interesting thing that I've found in just client services is sometimes a client will think that there has to be somebody that knows. There's cases where nobody knows the answer.
Exactly.
There
Yep.
where and I tell 'em, there's multiple levels of court for that reason, because not everything's spelled out. Sometimes you just Have to use your best judgment.
Well, and there are a lot of things in tax that you know I have immense due respect for tax attorneys, because if you're a tax attorney, that's all you can do. Just keeping up with the tax code is more than enough for a tax attorney to have to do. I'm trying to do trust and estate and probate and wills and trusts, and I do a little consumer bankruptcy as well. So for me to try to get up to speed on the tax laws, on the tax code of any given year, the vague generalities are as tight as I can go.
Well, on the bankruptcy side, you mentioned it's a specific type of bankruptcy. Can you tell me a little bit about that?
I do a lot of consumer bankruptcy. I do Chapter 7s and Chapter 13s for consumers. Um, Chapter 7 is just a straight discharge, and based on it's based on your income, whether or not you're qualified to actually file a Chapter 7. Excuse me, it's a 4-month process roughly in 90% of all cases. The Chapter 13 is a repayment plan option where I can put people into a Chapter 13 to either pay off back tax debt or arrears on a mortgage. I use Chapter 13 a lot to stop foreclosures on properties. If I file a Chapter 13, anywhere 5 minutes or more prior to an actual foreclosure sale, I've stopped that foreclosure sale regardless of whether or not I've told anybody or not. It gives the homeowner or the debtor the chance to reorganize those arrears, or the back their missed payments. And if in some cases, maybe they only have enough time to I can only buy them enough time to sell the house properly. But in those situations, they don't lose their equity. They can take their equity and go restart somewhere else. And so I use chapter.
And that's chapter 13.
Yes.
Mhm. And what's I hear this all the time. There's certain types of debts that just cannot be discharged or cannot be removed using certain types of bankruptcy. What do you know about that? Which ones are those? Because I've heard ones where, if let's say you start a business and you haven't paid your employers or employee side of the taxes, and the whole business goes under. Now all of a sudden you owe not only the government, but in a way you owe those employees, because these are withholdings to their own taxes that should have went to the IRS or the state. I've heard that that's a debt that's not dischargeable, and also things having to do with student loans. Do you know anything about that?
Well, student loans are essentially non-dischargeable, which is one of the big problems with student loans because people can never get out from underneath them. The taxes that you mentioned, the employment taxes, those are taxes that you withdraw from your employee's paycheck as a fiduciary, and they're considered trust fund taxes. You've taken money from that employee under the understanding you're going to pass that on to the federal government on that employee's behalf. So those are non-dischargeable as well because that was never your money. Um, Other than that, anything with the word fraud on it, if you get a judgment against you for fraud, that's non-dischargeable because fraud doesn't go away. Um, willful injury, DWI, things like that. None of those debts are dischargeable. Almost everything else is. Even income taxes can be dischargeable if the rules have been followed. If the taxes were due more than 3 years ago, you filed your return on time and just couldn't make the payments. After 2 years after your return's been filed, as long as there's been no new activity on that particular debt, you can actually use a Chapter 13 or even a Chapter 7 to discharge those taxes and get off under the income taxes. But as you said, employment taxes, those are sticking around because that was never your money to begin with.
Wow. Have you seen any cases that have to do with sales taxes? For instance, an e-commerce business that may have collected but then failed to remit the sales taxes. In a way, that kind of they are taking money that's not theirs. It's supposed to be remitted to a tax authority, and it wasn't. Do you know if that's the same thing or?
It's very similar. In my experience, the sales taxes can be discharged. It depends on how you've been filing your returns. If you haven't been filing your returns, then there is no dischargeability because you didn't. If you told the government, "Hey, I owe you this much money," and you just never paid it, that's one thing. But if you never told the government that you owed them any money, then you're not going to get the benefit of the bankruptcy court.
Really?
Yeah, and it's more along the lines of disclosure. If say you don't pay your taxes and the IRS comes after you, and the IRS decides that the amount that you owe is large enough to justify whatever their actions are, and they put a lien against all of your personal property or all of your property in general, then that means that the IRS has had time and had a fair opportunity to attempt to collect. If the IRS isn't given that fair opportunity or time to collect because you didn't file your taxes in a timely manner, then you don't get the benefit of the bankruptcy code. If you went ahead and filed, say you owed $100,000 in taxes this year on your income taxes, you filed your returns timely. They had a chance to go out there and charge you interest for a couple of several months or several years basically, and you're keeping them at bay somehow. 2 years after you file that return, in all likelihood, you'll be able to discharge those taxes in a bankruptcy.
But one the most common reaction for owing taxes and not having the money to pay it is what? Not file the taxes.
Filing, right.
And, and I tell people all the time, even if you don't have the money, file your taxes because there are so many doors that opens. You open the door to negotiate with the IRS before even having to go to bankruptcy. There are ways to negotiate with the IRS to put together an offer in compromise and just kind of,
Innocent
essentially.
spouse offering compromise, now and then there are different programs run by the IRS to clear that stuff up. But if you don't file, then you don't get the advantage of any of that.
Correct, correct. And they have payment plans too that some of them are pretty reasonable. So that's interesting that there's some overlap with that. You seem very knowledgeable about that on at least tax process side of it when it comes to the IRS. And it was very fascinating what you said about withholdings and not remitting them if you're an employer. I've seen this so many times where a company goes out of business, and I've seen it where years later, former business owners are contacting me looking for help with cleaning that up. And I see it all the time with individual taxpayers that worked somewhere and don't even have a W 2. And now, how do they even file their tax returns? They're missing the W 2. They don't really know how much was withheld. They're trying to piece it together based on whatever scraps of pay stub or something that they might have, and the employer's nowhere to be found. And the other thing is, when you stop paying ADP or your payment processor, a lot of times that information is gone.
Yeah.
So even the employer can't even go in and try to get this later.
I
So yeah.
I think in that situation, you can get to what the IRS would deem to be a good enough answer, right? You can ask for a tax transcript, and the IRS will estimate what they think that you were paid that year, and it's sort of up to you to prove them wrong, or agree with what they've said. But they can tell you what they think your tax liability should have been in a given year, and allow you to file based on that. So the IRS doesn't forget things. They tend to stick around forever.
Right, right. And one thing one option that we've had our clients take is file substitute for W-2. You've never gotten the W-2, you don't know, but you're allowed to file substitute for W-2 and put the most reasonable estimate that you have on there. And like you said, hash it out later if something else needs to be hashed out. But I'd say, now let's say somebody is a couple and they own a home. They're earning, call it 200, 300,000 a year as a couple. They're located in the San Francisco Bay Area. What do you, what's kind of a must have for this couple? And remember, most people have no estate or trust planning at all. What are kind of the three things that you say, this is what you need, or whatever number of things? What are the must haves for this situation?
There are three must haves. You really need you need to have a will, okay, to take care of any mistakes that are made in funding the trust in California. Um, so if you have a will basically saying that everything goes to my wife or everything goes to my trust, then you've accomplished a lot there. The big thing that you really have, you have to remember that the will has no meaning until you're dead. If you have a trust, the trust has a meaning while you're still alive. The trust can step in when you're incapacitated or you're missing. Whoever the substitute trustee is, whether it's your other spouse or somebody down the line, they can act on your behalf or act in your best interest on the behalf of the trust on your property and make sure that the property goes where it needs to be. Say you're lying in a hospital bed and can't or unable to make decisions. You really need to have that. The trust is there to allow for things to happen while you're still alive. The other the other the other useful tool to have in that situation is a durable power of attorney. a power of attorney that says, even if I'm incapacitated, this person has the right to exercise the powers that I've listed in this document, whether it's real estate, financial, or other, on my behalf.
Oh, wow. Who's the person that receives that? Is that usually the spouse? Is that a parent? Is that a child? Who is the holder of this durable power of attorney?
In most of the cases, it's the surviving spouse, it's the other spouse, and then after that spouse is gone, then there are I always ask for 2 or 3 people to list below the spouse, just in case. The big use case is when, um, both of the spouses are really, really very elderly and maybe can't keep up with the demands of managing their finances or managing their real estate. If you've got a second person listed, then maybe a child or a close friend who's younger or is pretty sharp, then things can continue to happen without any unnecessary delay. So if you've got the power of attorney, if it's the other spouse and the other spouse is in great shape, then the other spouse can just step in and say, "Look, I've got the power of attorney. I can sue on their behalf. I can sell or take loans against real estate. I can act for them in any legal manner, and they've got the authority at that point."
Got it. Now, there's some terminology that have to do with estates that can be very confusing. What is the difference between the administrator, okay, or executor of the state, and what are some other uh, um, you know, kind of roles that could be in there? For instance, somebody that monitors the estate. What are some of the roles that you've seen that and who normally takes these roles?
Okay. So remember, an executor is limited to a will. You have an executor of a will. That will may or may not have any purpose. Most of the I think 95% of the wills that I draw up basically say everything goes to my trust, which means that the trust is the document that's supposed to be focused on administering the estate, either during incapacity or after the death of a person. Okay. In the trust, you've got the settlers, who are the people putting the money into the trust. Then you've got trustees. The trustees are typically the husband and wife that have just move their property into a trust as settlers. But you can define trustee succession, which after the husband is gone or after the wife is gone, and after both spouses are gone, these are the people who are then in charge of following the trust document for either tax or distribution purposes and making sure the beneficiaries get everything that they're entitled to. The other name you might want to think of is attorney in fact. It's also known as an agent. The attorney in fact is the person nominated by a power of attorney to act on behalf of the person granting the power of attorney. And usually, again, in most situations, it's the surviving spouse with a couple of backups named after that.
Got it, got it. Okay, so you're allowed to have some backups.
Yes. Yes. You can define backups as far down the line as you want. You can also you can also define prohibited persons, people that you just know you do not want in charge of your trust, even if they're beneficiaries. Maybe you've got a very dysfunctional child, and you want to make sure that that child never has access to the position of trustee because you know that they're either incapable or unwilling to act on behalf of all the beneficiaries equally. When you're a trustee, you've got a fiduciary duty to act on behalf of all of the trustees. It's required. If you're not able to do that, then being the trustee can be much more of a penalty than a benefit.
So you can specify who you don't want to be involved in the estate.
Exactly. And in my trusts, I also include options for appointing a trustee. Say, husband's gone, wife is gone, the most responsible child for some reason is gone or unwilling to act as trustee. At a minimum, I always say that a party in interest can go to the court and say, "Hey, please appoint this person or appoint an independent trustee to act as trustee because everybody else is no longer in the picture." Because you never want to have assets sitting in a trust that no one has control over.
Got it, got it, got it. Okay, okay. Um, Now one question that, and this is the toughest one, okay, and this is another reason why people avoid this. the expense. Okay. Let's say somebody is uh let's say you have the fictional couple that I was talking about that earn 300,000 a year, live in the San Francisco Bay Area, own a home worth $2 million, have one child, both have 401ks, and have a stock plan with their employers. And maybe they were thinking about possibly buying a rental property, but it hasn't happened yet. Okay. So with somebody like this, what if they wanted to actually do everything correctly? Everything correctly meaning home is in a trust, they have the wills, they have everything set up correctly as you outlined. What can they budget in their mind, kind of as a range for how much they need to invest in essentially their own, in their own planning?
That's a great question, George. And in fact, I love creating basic estate plans. Revocable living trust, pour over will, powers of attorney, healthcare powers of attorney, general assignments, and then the deeds. I do that for a flat fee. I do that for a flat fee for a married couple of $3,900, $3,900. Um, and the only extra charges are charges that the counties charge me to record trust transfer deeds for real property. That includes your trust, your wills, your powers of attorney, your healthcare documents. I'm also a notary, so I bring when everything's ready to go. I bring you into the office. I notarize everything for you, make sure it's all executed correctly. Because I see that a lot. I see people going to seminars and getting these generic trust documents, filling them in, and then never actually executing them. Um, and so I make sure everything's done. I scan all the signed documents in, so I've got a scanned copy of exactly what was signed that day. Then I give you back the originals, so you're not tied to me forever. You can come back to me for modifications and adjustments if necessary, but you don't have to. We draft all the deeds for you, at least for the deeds here in California. We draft those ourselves. Deeds outside of the state, we send those to a third party provider, and we just bill the fees for recording. Um, and the recording at the county level, and for our time spent in recording, we bill those after everything else is done. So for in the situation you mentioned, $3,900 gets everything other than the recording of the deed to transfer the house to the trust, and that's going to cost somewhere between 23 and $250. That's why I bill it after the fact, because it's become impossible for me to really predict what the county's going to charge me. So I gave up, decided I would just bill it after.
Got it. And if the couple lives outside of California, let's say they live in Washington, but they own a property in California, should that property still be put in a trust?
My understanding of conflict of laws, and I've actually I've done some work in this area. As long as the document is valid in the state that it was signed, and there are some other rules applying to that as well, then that's the document. That document is appropriate for use in any other state. So if they
Got it.
well, in that situation, if they came to California, got their estate plan done in California, as long as it's done appropriately in California, then it will transfer properly. There may be other state wrinkles that I'm not aware of, or I don't understand fully, but that's my core understanding of the issue.
Got it. Is there a specific client type that you would say is the kind that you end up seeing the most and you end up helping the most? Is there some kind of specific kind of category of client that you think is just the most common? And by the way, that fee is very reasonable, for professional services in 2025, especially something as important as having your family's future put together. It's a very reasonable fee. What would you say is kind of your main thing that people tend to approach you with?
I get two different types of clients that we consider my primary estate planning clients. The first client is a couple in their 30s that own a house, maybe one or two houses, and they've got minor children, and they want to have things set up so that their minor children have guardians appointed for them properly. That their estates are held in trust for those kids, and the money given out over the course of time to those children, so they don't get it all at once. Um, those are really good clients, in my opinion. The client I get more often in the Bay Area are people in their 60s and 70s who are now retired, and they've had some time to sit and think about it, and maybe one of their friends dies without a will or a trust, and that now they see the surviving spouse or the children start to jump through hoops to try to get everything distributed to everybody. The Those are the ones that come in quite frequently because no one ever, like I think you mentioned this earlier, no one ever wants to think about what's going to happen when they're gone because no one wants to die. And so I get to have great conversations with people like, well, what happens if all of your children are dead? Which is not much fun to have. But it's a realistic perspective. What are you going to do? Where do you want things to go? Things should go somewhere, and somebody should be in charge of making them go there. Otherwise, the state takes over. The state takes over and opens a probate and gives it out to second and third cousins. Maybe there's somebody that you really want to somebody you really want to take care of. Maybe you've got charities that you really want to support after you're gone. I'm in Rotary. Maybe you want to make sure that Rotary gets a large chunk of money and is able to you know work at their charitable ends. If you do that in a trust or if you do that in your will, then you can count on that happening. If you don't do that, then you're leaving those charities that you maybe support now high and dry, and they get nothing.
Wow, that's a really good point. People don't want to think about the scenario of, um, you know, multiple members of their family maybe not being around, but it's kind of it's kind of like what you mentioned. There needs to be a second or third or fourth plan that's available. Plan B, C, and D.
What's nice about the trust and estate plans that I draft up is that's sort of built in. We don't have to have in-depth discussions about what happens if we all go down in a plane crash. There are defaults that take over at a certain point. At a certain point, even the trust says, just give my stuff to who would get it under California law. So that's sort of the very last fallback. But at least you've handled as many situations as you can short of that, and you've tried to make your estate mean something to you. One of the reasons why I'm licensed in Wyoming, back during COVID, I went and took a second bar exam, which very few attorneys ever do. It was nuts. I just decided I was going to go ahead and study up again, take another bar exam. I got licensed in Montana. That's where I someday want to retire. But I got licensed in Wyoming because of the way they treat anonymous business formation and domestic asset protection trusts. In most states, you cannot create a first party domestic asset protection trust. In Wyoming, you can create a domestic asset protection trust that has a Wyoming trustee and yourself as the other trustee that are designed to shut down in the event that you're actually sued and make those assets unavailable for use by creditors. So if you form a domestic asset protection trust in Wyoming, you can create a wholly owned LLC of that domestic asset protection trust, use that asset protection trust to conduct business, and you don't have liability back to the domestic asset protection trust. And Wyoming has a number of benefits there. They've got an entire court system that they recently opened called the Chancery Court, where all trust litigation matters can be taken. So they've got a special court just designed for this. You may have heard of the rule against perpetuities, which is essentially a deadline. In most cases, it's 21 years after the death of a life in being. It's an incredibly complex statute to understand. Even the Supreme Court gets confused on this one. But in most states, it's 21 years after a life. In Wyoming, it's 999 years after a life. So you can have essentially a perpetually existing trust in Wyoming that never ages out of that. So there are a number of advantages in Wyoming that make it a really great place for asset protection.
So for asset protection, if somebody, let's say they are a California resident, they own a California business that they own and operate in California, can they shift the ownership shares of that business to Wyoming? Obviously, they're going to still be compliant with California state taxes and paying whatever they're required to, because, Wyoming doesn't have that income tax, but California does. But you're still operating the California business. And in this example, the client has created this separate asset protection trust in Wyoming, and everything is owned by it. Okay, if creditors or if there's lawsuits against this person in any state, does that mean that their assets are protected?
To the extent that the assets are Wyoming property, if it's money in a Wyoming bank, that asset would likely be protected. Assets in California, in order to operate an entity in California that's not registered in California, you have to register as a foreign entity, which is basically say it's a filing with the Secretary of State that says, "Hey, this entity is owned by this entity in Wyoming, and here's its certificate of good standing, and it's a valid entity there." You're still exposed in California to the extent that you have operations there.
Got it. Got it. Awesome. Well, this has been super helpful. I have to wrap up because I have to get on a client call right after. But what we'll do is anybody that has seen this that has questions for me or Jeff, you'll have our contact information there. Please reach out to us. We're super easy to get a hold of. Email is great for me. You can reach out to us directly over email, or a phone is completely fine too. You can reach out to us on any of our socials. If you don't if you don't receive a response within a day, just call us. Same thing applies for Jeff. Jeff is super, super easy to reach over email. That's how we communicate. So I know that from experience. But Jeff will also provide his other contact information there. And if anybody here has any questions, we're both happy to help.